Good afternoon, ladies and gentlemen, and happy Thanksgiving. It's Wednesday night, the night before Thanksgiving. I'm Steve Young, and I welcome you to this question and answer session in our free, what I call Mentors webinar, where for the next hour, I'm going to talk about some things related to trial, field questions from you, hopefully answer questions for you in a way that helps you with your cases and your trials, and benefits everybody through the exchange of questions and advice that we're going to share in today's webinar. What I'd like to do first is give you just a brief overview of what we're going to do today. I have done 4 webinars on jury selection over the last month, and we've had remarkable attendance, and I think that we've discussed some very meaningful things that have helped the people who have been on the webinars. What I'd like to do is extend that with a program that I'm going to start. I may do this once a month or so, where I am going to go on a webinar session such as this and simply field questions from people about your cases, questions that you have, problems that come up. How do you deal with such and so? Because many times in this world of law where we are engaged in the battle seeking justice either on the plaintiff side or the defense side, you may be in a firm by yourself or in a firm that isn't helpful in terms of offering advice and expects you to figure out what to do for yourself. Well, many people do that and they come up with solutions, they come up with ideas, but they may not be the best ideas. And they're not really learning or progressing as a result of that. Through the free exchange of questions and answers and the things that we're going to discuss, I hope to be able to broaden and strengthen your abilities and confidence in the courtroom by giving you some answers to questions you have and providing tools that you can use in the course of trying cases or getting cases ready for trial and having them settle. The second thing that we're going to do today is, for those of you that hang around for the entire hour, I'm going to make an offer. In fact, I'm going to make 2 offers to you at the end of the webinar. Offers that can save you some money, can give you access to the upcoming webinars that we have. We'll give you some codes that get you reduced prices on archive sessions of the webinars that we've done in the past, etc. If you stay to the end, we'll give you those codes and you'll be able to take advantage of the special offers that we're making at this time. I'd like to begin by giving a bit of background on myself so that you know the weight that you can give to the opinions, to the suggestions that I'm going to make today. I've been an attorney for 34 years. When January comes, I'll be able to claim 35 years. And during that time, I've tried almost 200 civil jury trials. I graduated from Pepperdine University in 1980 and practiced in California ever since. I've got a membership in the Washington State Bar and the California State Bar, the Ninth Circuit Court of Appeals, and all of the federal district courts in the California state federal court system. But more than that, I have the experience of going to trial and doing so outside the box. There are a couple of things that, if people don't have questions tonight, I will suggest from my own experience. But one of the things that I like to do is approach a case in a way that my opponent doesn't expect, and then in effect creates a situation where the opponent is trying my case for me. And we'll talk about this later on in today's sessions. I want to share with you a story from my past. I grew up the son of a nurse and an aerospace inspector. My father had a high school education. My mother, when I was younger, had an associate's degree as a nurse so she could be a registered nurse. And when I was in college, she went back to school to get her bachelor's degree. She was one of the, I don't want to say one of the, my mother was the smartest woman in the world. She could do algebra in her head. She got 4.0 throughout the time that she was going for her associate's degree and her bachelor's degree at the same university that I was going to. She was present in terms of psychological use of tools that she had. She was just a phenomenal person. And she taught me that one of the greatest ways to exhibit strength is to allow people to see your weaknesses. And this was a very empowering thing to me. One of the things that we don't understand until we have walked this road, until you've gone to trial many times, unless you've spent a lot of time trying to become self-actualized, is that the strong person is not the one with the loudest voice or the biggest muscles or the greatest bluster. Instead, the person who is truly strong is the one who has the strength and courage to show their weaknesses. And by showing their weaknesses, create bridges of connection and transference that draws on the strengths and powers of others as they try to help the person with their challenges. And this is one of the great lessons I learned from my mother, that I now apply when I am in litigation and more so when I'm in trial. The second thing I want to share as a qualifier for me to speak today. My father graduated from high school before 1930. The Depression hadn't hit yet. He grew up on a poor dirt farm. He had 10 brothers and sisters. His father was a coal miner. His next younger brother, my dad was the oldest, dropped out of school in the 8th grade and went to work in the coal mines with my grandfather. My dad always resented the fact that his brother curried favor with his father by failing, by dropping out. And my grandfather always favored this brother as opposed to my father. My father, in the face of all of this, continued through and graduated from high school because it is something that he said, when you start, you have to finish. My father graduated from high school when he was only 5'3". And to this day, he still holds all the scoring records in basketball for his high school. And when I was young, he told me his regimen. In the morning, he would wake up, he would go out and do his chores in the dark, he would then come to the house, clean up, have breakfast, and he would run 3 miles to school, arriving an hour before school where he would shoot baskets for an hour. He would attend school. At the end of school, they held basketball practice. They didn't have buses back in those days for the school children, so at the end of basketball practice, he would run 3 miles home. He would do his evening chores. He would then have dinner and do his homework and go to bed, and that was my father's day. And he was doing all of this in the face of opposition and resistance from his father, who wanted my father to drop out of high school and go to work in the mines to help support the family. These two great lessons from my parents, one, that gentleness is actually the greatest strength and the ability to be open and reveal yourself, and the power of determination. Because my father did something else besides play basketball when he was in high school. My dad was a public speaker, and he went to this little podunk high school, a company town, a coal company town, with a little schoolhouse in eastern Oklahoma, just west of the Arkansas border near Fort Smith. And he won the school public speaking contest and went to the regionals and won the regionals. And with no small bit of pride, he told the story of telling his father that he had to go to Oklahoma City for the state public speaking championships for Oklahoma high schools. And his father put his arm around my dad's shoulders and said, we have to get you a suit because I don't want anybody thinking that you're a hayseed. To make a long story short, they got the suit. My dad traveled to Oklahoma City by himself. He came back with the trophy as the Oklahoma State High School Public Speaking Champion. Again, my father's determination that I believe has filtered into me, and I attempt to honor every time I go into trial. So if you accept that as qualifications for speaking today, I welcome you onto our webinar. This is about questions and answers. I have a chat box on the left-hand margin. It may be a little hard to see, but if you look, it will say chat there. It may be just a small box, but you can put your questions in that, or you can tweet them to @YoungOnTrials or email them to steve@youngontrials.com. I would like to start this off with a question that I received today from an experienced lawyer. The lawyer had called my office to talk about a case that had just come into her office. And in the course of the discussion, she told me about a deposition session that she had just had in another case that was driving her crazy. And I said, well, what happened? She said, you won't believe it. The woman, the deponent, answered a bunch of interrogatories and then goes to deposition and gives answers that are completely opposite from the interrogatory answers that she gave. And then when she reviewed the deposition transcript, she went through and changed all of the answers in her deposition transcript. I am going to murder her at trial. I asked her, may I make a suggestion? And she says, yes, what's that? I said, I suggest that you don't murder her at trial. And she laughed. I think she thought I was making a joke. I was serious, because I proceeded to tell her that if she takes that approach, she's going to be using the same approach that about 90% of the attorneys out there use, that is absolutely wrong. When you went to law school, you probably had the experience of a law school professor who taught you how to impeach with a prior inconsistent statement. And so everybody wants inconsistent statements in the deposition that they can roll out to read to the jury and embarrass the witness, even if the testimony that the witness has given helps the party's case. The jury doesn't understand what's happening one way or the other. And I explained this to my friend and then made the suggestion that I'd like to pass on to you. The most important thing that you can do in trial is tell a compelling story. And the way that you make a story compelling is not for you to tell the story or your client to tell the story, but if you can tell the story through the mouth of your opponent and show that it is your opponent who says this and says this and says this and says this. My recommendation to my friend, get your discovery responses, get the deposition transcript, get the deposition changes, and find each place where the response, the testimony, or the changes support the story that you want to tell in trial. And then as you're telling your story, for example, in opening statement, if you're allowed to use an Elmo and show documents to the jury, on such and such a day, the other side did this, and here is her interrogatory answer showing that they acknowledge that they did it. And then what they did is, I will read from her deposition, then I did this. And then she did the next thing, which is even more important, because in a deposition she gave one answer and realized it wasn't right, and after coolly, calmly considering it and talking with her attorney, she crossed out that answer and told us in a corrected transcript of the deposition that she then did this. And what you do is you tell the story with the words of your opponent. And then no matter what your opponent says, the jury says, yeah, but we know that what you said establishes the entire case. Why are you wasting our time? You don't have to destroy somebody. The members of the jury think that every attorney can make any witness look stupid, so you don't accomplish anything with a prior inconsistent statement if your whole purpose is to make the person look stupid. And if you're using the prior inconsistent statement to impeach rather than to advance your story, in order to do that, you have to have had testimony that actually supports your story, and now you're using an inconsistent statement that the jury has no idea why you're reading this statement that they thought is different from what your story is. The suggestion, keep your case clean by using the testimony, whichever way it comes, either testimony or the deposition or whatever you're using to impeach. Use it in a way that's consistent with your story and not just an impeachment, and you will find that the jury gets the story, which is your goal in trial anyway. Your goal is not to embarrass, to impeach, to make look bad the other side. Your goal is to tell your story in a way that the jury accepts, and the best way to do it is with the words of your opponent. I have a second area that I'd like to talk to you about as we wait for questions to begin filtering in. Again, you can submit them in the chat box, through Twitter, or at an email address that's on the screen. But it's the issue of deposition objections. I'm involved in a rather acrimonious case right now. I represent a young man who was shot 5 times by the local sheriff's department. A motorcycle officer who's not supposed to make arrests, who's not supposed to engage in pursuits, waited for my client to arrive at his home and then pulled up behind him on his motorcycle, and before he ever stopped the motorcycle was pulling his handgun, and within 30 seconds had shot my client 5 times. One of the big defense tactics that you see in these types of cases, more so than other cases, is the absolute obstruction of not producing relevant documents, even though they've been requested. There's no privilege. There's no real objection. The strategy is to withhold everything, and in deposition, to obstruct everything. So I've been taking depositions of deputies who were monitoring traffic, who were dealing with the case, who arrived on the scene, etc. As I'm doing this, I get objections from the attorney who's attending the deposition. Now, we've all been through depositions where the other side makes an objection, and it's an invitation for an argument, a fight, screaming, yelling, people's genealogy is invoked, new curse words are invented, etc. I learned a long time ago that if someone is making a real objection to a question, I need to pay attention to it. And rather than arguing with the objection or insisting on an answer, ignoring the objection, I have now implemented a new dialogue in my deposition repertoire. And my response to an objection is, "Thank you, I'll withdraw that question and ask it a different way." And what I do is I then ask the question taking into account the objection so that the objection doesn't survive. If they assert the same objection, I think that I have resolved the issue with the way I've reframed my question. I say, "Thank you, I'd like an answer from the witness." I don't get involved in arguing about it anymore. I really don't care. If I'm on the other side, or I'm asking questions and the other side instructs not to answer, rather than arguing or fighting about that, in our state we have a provision, 2025-240 of the Code of Civil Procedure, that allows me to have the court reporter cite the witness or party into court to show cause why they shouldn't be compelled to answer the question. And rather than dealing with the issue of the instruction not to answer, I simply have the citation made. I've already picked the hearing date. I know what the department is, and I write up a little script for the court reporter before I get to the deposition. If the occasion comes up that someone's instructed not to answer, I simply hand the script to the court reporter and ask her to cite the witness into court on an order to show cause why they shouldn't be compelled to answer, and that usually puts an end to the dispute. I used this tactic in a large class action case that I have with a $2 billion damage model in it against a Fortune 500 company. We were deposing a person who was the person most knowledgeable concerning the payroll systems for this company, and she was instructed not to answer on a question that was very straightforward and easy and within her realm of experience, and the instruction not to answer, which frankly should only be used in the case of a privilege that you're asserting to protect the privilege. In the face of that, I simply had the reporter cite the witness into court. So we show up at court, and the international law firm that I'm against in this case was jumping up and down and angry, and what an abuse it is to make this witness who was residing in Texas have to show up in California to et cetera, et cetera. And the judge said, I'm going to order her to answer. The deposition will resume right after this hearing. Mr. Young, how quickly can you get your court reporter? I said, I'll get him right after this hearing, Your Honor. We went back, and greatly chastened, we got some phenomenal information from that witness because the international firm's attorney was now not so quick to instruct not to answer, and the witness saw that her attorneys were fallible and that the judge cut through all the crap, and it really advanced the ball for us on that case. Another tactic that I want to share with you. The one thing that I have learned in every trial is that there is a certain distrust or dislike by jurors towards attorneys, particularly if they act like attorneys. I've developed a rule. I call it the nicest attorney wins rule. And it goes something like this. Why act like the other side? Let them act that way because the jury doesn't like a bit of it. I had a judge one time tell me, Mr. Young, you apologize more than any trial lawyer I have ever seen. To which I respond, I'm sorry, Your Honor. And he laughed. But what happens is if I ask a question and the witness doesn't seem to understand, I say, I'm sorry. I'm responsible for asking questions you can understand. Let me try that again. If the witness is giving an answer and pauses and I begin with my next question and he then resumes his answer, oh, I'm sorry, I didn't understand that you weren't finished yet. I'll let you finish and then I'll ask your next question. I go out of my way to be solicitous of witnesses, even opponents. I go out of my way to be nice. I do what I call a gentle cross, where I figure out what it is that I need from each witness to advance my case, and then I just ask about it. And I ask in a nice way, polite way. If I have to get tough with somebody, I don't do it until I've established a basis with the jury where they understand that I have to do this in order to get the information that I need after trying everything else that I can to get it. And you'll know when you have permission to do it. And the jury then sits back and waits to watch the show. This is the lesson that I learned from my mother. Gentleness is the greatest strength. And the more you fight gentleness, the worse you appear. So the nicest attorney wins. Now, I've got a question from Randolph Ramirez. He asks, what is the first thing you look at when taking on a case? How does your approach change when you come on board last minute on a case going to trial? That's actually two very, very good questions. I will answer the second question first. I have developed a model for myself based on last-minute trials. I was a solo practitioner many years ago. I sat down and figured out what I liked about law and what I didn't like about law. And the things that I didn't like about law were the arguments and depositions, the bullshit law in motion that we all have to deal with, the animosity, the acrimony, the discourtesy, And everything that I liked occurred at trial when the jury was there and you had 24 eyes watching everybody, so everybody was on their best behavior. And I thought to myself, if I do more trials, I end up with less of what I don't like. And so I put together an ad and I put it in the paper. I figured out how I would assimilate information quickly, touch documents only one time as I was going through a file, and have all of the information at my fingertips. And I've developed my own system for doing this. And what I've been able to do with this, I have accepted cases on a Sunday night and began picking a jury on Monday as a plaintiff in a case with a very difficult judge. That was my record for the shortest time between engagement and appearance at trial until August of this year, when I was hired to step into a case midway through the trial as the defense attorney, and got there in time for the judge to accept my substitution in the case and say, "Mr. Young, it's time for the defense to proceed. You may call your first witness." I told the judge, "We don't plan on calling any witnesses, Your Honor." She said, "Fine, Mr. Young and counsel, you can be ready for closing argument tomorrow morning at 9 a.m. And I came back and gave a closing argument, and we ended up knocking out 3/4 of the plaintiff's case just based on what I could see from the documents that had been admitted, and we then settled the case, and the client was very happy with that. My approach is therefore tempered by this model. My preference is a last-minute trial because I prefer trials. My approach to preparing the case is always the same. If I have a case from the beginning, I touch the paper one time. I use my system. It's the same thing I do coming in at the last minute. If I'm preparing the complaint, I get the jury instructions that list the elements of what I'm going to have to prove, and then I write a literary style complaint, a literary narrative, telling a story in first person present tense from the plaintiff's standpoint of what happened to them and why it hurts so much. Same thing if I'm doing a affirmative defenses in an answer for a defendant. The whole case is tempered by the story and the support for the story, and how am I going to prove my story, just like these deposition examples that I started with at the beginning. I am looking for a way to relay and prove to the jury what it is that is the rudimentary story of my client's case in a compelling way. In fact, I have a statement hanging above my desk that I look at every time I prepare anything, and that is a good brief or a good case or a good story or a good argument, I've added all of those in, starts with a plain English statement of the problem to be decided in a way that subtly leads to a win for you. One of the most powerful appellate briefs I ever wrote on a case that was a heartbreaker that I lost and ended up winning on appeal. A young boy, age 6, had been killed at the front end of a bus that he'd been let off from on his first day in school, and he was let off at the wrong stop in April. So it wasn't that everybody was new, he was the only new kid. And the jury had found no negligence. My appellate brief in that case began with an introduction. The first sentence said, "Barbara L. and her daughter Katie sat on the curb of the bus stop waiting for her son Tommy to arrive home. It was his first day on the bus. The family had moved from New York to California the day before so the father could spend more time with his family." That's how I opened that brief, and I proceeded to tell the story of the sirens at the bottom of the hill and of the mother rushing down the hill because she got scared when the bus didn't come on time, and the bus driver's response when she asked, "Was it my son? Was it my son?" looking at the little body under the sheet, and the bus driver's response, "I don't know, lady." And it had such a compelling effect upon the Court of Appeals justices that a finding of no negligence, which is a factual finding, in no way it should have been reversed or vacated by the Court of Appeals, was vacated and remanded for retrial by the Court of Appeals on the grounds that the school district was absolutely responsible for that child and his safety until he was returned to his mother at the end of the day. That's what I mean by getting to the story. So I begin my cases that way. I don't have that liberty when I'm coming in at the last minute. I'm looking for the story. And I began to build the story through the assembly of the evidence and the chronologies that I use and the witness memos that I put together so that I know what the evidence is and the story develops from that. So that's the difference in approach between a last-minute trial and a case that I'm in at the beginning. Now, the first question is a deeper and more difficult question, and that is, what is the first thing that I look at when I take on a case? It's actually a simple answer for me, but it may not be the answer for you. When I sit down with a client, I want to know two things. Is this someone that I would like as a friend, someone that I feel like I am going to develop a love for, because that's how I feel about all of my clients. So I want a good person. I want someone who's a person that I can be a friend with because my relationship is going to become very deep with that person. And the second thing that I look for, is there a compelling story that touches my heart? You don't have this liberty if you're representing a defendant. You may have a story of outrage or betrayal. You can have a story where you care about the defendant and feel like they're being wronged and you feel this sense of need to protect them. Then that's a defense case that you take. But for me, it's this almost intangible of, do I like the person? Do I like the story? Because if I do, that's a leg up. I have my assistant, who's not a lawyer, hasn't been to paralegal school, but is phenomenal at all of this stuff. She does all of my intake. And she hears the people tell their story first over the telephone and looks at the documents. And she tells me what she feels about it. That's my first mock jury. So like I say, I want someone with a story that I like, both the person and the story. Now, next question, Brian Custy. I recently tried a trade secrets case where the judge was hostile to my client and its claims. The defendant was a pillar corporation in the community and well connected. When my main witness testified, the judge repeatedly reprimanded him and rolled his eyes at his testimony. When the defense had my primary witness on cross and was struggling, at the end of the day, the judge broke court at 3:30 p.m. so the defense counsel could regroup and start again with the witness the next day. What can one do when the judge acts in these ways in front of the jury? There is a balancing act that you deal with when you have a bad judge in front of a jury. And that balancing is, do I take the judge on in front of the jury to create my appellate record that I'm going to need if I have to challenge this, or do I trust the jury to see what's going on and do justice? I was brought in last minute to try a medical malpractice case in Beverly Hills. It was a case involving a revision of a breast enhancement surgery. A woman had problems with implants that she'd had put in 17 years before, and a very well-respected, highly regarded doctor who was a consultant with our local CBS affiliate on medical ethics issues was the defendant. My opponent was a trial lawyer who was with a firm that specialized in medical malpractice defense and had bragged repeatedly to anyone who had his or whose ear he could get that he had not lost a case in 20 years and that he had a 98% win rate during his total career. And this judge looked at him as the source authority for everything malpractice. She would sustain his objections. She would condescend to me because I was just a young, smarty-aleck little kid. But it was interesting. She had a rule that you couldn't show any exhibits to the jury until they were admitted in evidence. She had a rule that you couldn't admit your exhibits until the end of the case. And so my first witness was my client, and I had a black binder with about 300 photographs, because what happened is during the course of the surgery, the doctor had wrapped her too tight, and her nipples had necroted, turned black. The areola and nipples, meaning they'd died. So she lost feeling in that most tender of areas for a woman. I had my client on the stand. I walked her through her story. I moved to admit the photographs as we went. The judge kept overruling them. The judge wouldn't let me show them to the jury. She told me I had to leave the binder closed on the front of the witness stand. And my client finished her testimony. I passed the witness, and the defense attorney stands. First thing he does is he takes out 3 panels of blow-up photographs mounted on foam core and walks up and pops them on an easel in front of the jury. I object. Your Honor, there's no foundation for this. They haven't been admitted in evidence. They shouldn't be shown to the jury. This judge says, Mr. Young, please be quiet. Allow Mr. M to conduct his cross-examination and don't interrupt like that. You know that's not proper. I am feeling probably much the same as Brian did with his client after trying to put on the testimony and watching the debacle that cross-examination was and the judge's rescue. So the examination begins. And Mr. Slick is up there pointing to the photographs and asking all kinds of questions. And I'm objecting my client lacks foundation as to the medical issues that he's asking about. All that she can talk about is what her breasts look like, what she can see, and what she felt. And again, I get slapped and slapped and slapped by the judge. Finally, one of the jurors, sitting closest to the witness box on the front row, says, Your Honor, are we ever going to get to see the photographs in the black binder that Mr. Young had? The judge goes, What? What did you say? This woman says, Your Honor, do we get to see the photographs in Mr. Young's exhibit binder? Well, not yet. They haven't been admitted in evidence. The juror smiles. She points at the 3 panels. She says, have these photographs been admitted in evidence that Mr. M is showing to us? The judge got huffy with the juror and said, this is just for demonstrative purposes. They're not in evidence. The juror says, why is he getting to expose them then if they're not in evidence? It doesn't seem fair to me. The judge slapped down the juror. It was very interesting because during the course of the trial after that, the jurors were constantly submitting written questions to the judge and asking questions from the box that the judge would continually tell them that that's not their place to ask questions. It came time for deliberations, and the jury came back, and after 20 years of not winning or not losing a case, Mr. M was handed his first defeat because the jurors revolted against the unfairness that they saw exhibited by the judge. It is a balancing test. You have to make the decision based on the types of jurors you have and the type of, I'll call it, misconduct that you're confronted with, whether the jurors are going to be able to see and fix this. I had a case of a near-fatal drowning. A beautiful woman in her 30s went in to rescue a child that was in trouble in a deep end of a swimming pool. She couldn't swim, and she ended up on the bottom of the pool so long that her brain was oxygen deprived, and at age 30 she was now reduced to the abilities and talents of a toddler. And I had a judge who made all sorts of arbitrary limitations on the timeline and things that we could do in our trial. And finally, in front of the judge and the jury, in frustration, when she had allowed the other side to cross-examine on issues outside her limits, and I came back on redirect to examine within those very same limits that she had just allowed them to cross-examine on, she started to slap me down, and I said, "Your Honor, you allowed it. You opened the door. I'm entitled to examine on it." And she says, "I don't want to have to admonish you, Mr. Young, in front of the jury." And I threw my hands out almost like I was being nailed to a cross and said, "Your Honor, admonish me. This is not fair. Admonish me right here in front of the jury if you think that's appropriate." What happened next was so surprising to me. This judge didn't say a word. She called a recess and ran from the bench. The jury walked out. They were watching interesting drama. It came back as an interesting result in the case. All that I'm saying is you have to be conscious of where you are, what you are capable of doing in terms of either taking on the judge or letting the jury do it for you. It is something that comes with experience. But the one thing that you can do that is absolutely safe, you need to make your record during the breaks. If the judge is interfering, if he's rolling his eyes, if he's making comments that you think are inappropriate, if something has happened, you need to object on the break so that you preserve your record and your objection. In these situations where I was telling you about the problems with the judge in the malpractice case, I made my objections as to what was going on break, because that's how I had to get it into the record. It's not always appropriate to do it in front of the jury. Now, a footnote to the malpractice trial. For 4 months after that trial, I had a number of associates working in that law firm come up to me, people I didn't even know, and tell me, "Thank you. We are so tired of hearing of his win-loss record and how long it's been since he's lost, and we don't have to worry about it now because he's got a loss. Thank you." So, another question's come in, again from Brian. "Unfortunately, the judge took my case from the jury. I had hoped the jury would see what was going on. We'll see what the Court of Appeals thinks. The one issue that you have, and you need to consider this, I don't know if you filed your appeal yet, but you need to make sure that you dot all your I's and cross all your T's on post-trial motions. If a judge grants a non-suit or a directed verdict, you're entitled to bring a motion for new trial. If he grants a directed verdict, you have a motion for judgment notwithstanding the verdict. Many jurisdictions require that you make these motions as a predicate to your appeal so that the judge has the opportunity to correct the mistake before you get on appeal. So if you haven't actually filed your appeal yet, I would suggest you look at these to make sure that you've dotted all your I's and crossed all of your T's. Now, one of the things that I encounter in trial is this issue of how much time do you spend preparing your witnesses. One of the biggest problems that I see attorneys engaging in is they want to be the controllers of the entire case. They think they know the story, they think they know how best to tell it, and they start creating a story that they want to shoehorn their client's testimony into because they want the testimony to conform to the attorney's version of the facts rather than the attorney conforming his presentation to the client's story. There is a real issue with this because the attorneys don't know the story. You may think you do. I've been in cases where I thought I knew what the story was, and it took a 180-degree turn. I was in a federal trial once, and it was a strange time for me to be in trial because at the same time I was running a losing political campaign for Congress as a Democrat in a highly Republican jurisdiction, congressional district, and someone came to me and asked me to try a federal case. So I took on this federal case. The pretrial statement was so bad before I got into the case that the judge threw it out when I showed up. And he said, we're just going to try this as a trial, which was actually a godsend to me. And I assembled all of my exhibit books, including a document that to me, the guy must have been stoned when he wrote it because none of the figures made any sense whatsoever. And we go through the trial, and I'm again against a large international law firm with an attorney dealing in an area that was his specialty, and we're presenting the case, and he may have had a specialty, but it wasn't trial. I get all of my exhibits in, including this funky document. We finish the trial, and the judge says, I'm going to set closing argument for 3 weeks hence on Wednesday at 1:30 in the afternoon. I go back to my office, and I start examining my notes and looking at the documents, as I do when I have time to prepare closes in this way. And all of a sudden, I realized that I had been misreading this funky document the whole time. And this funky document was only a half-page email with figures in it, but it was like I was reading it with the Rosetta Stone for the first time. I made multiple copies of it. I highlighted some sections of it. I showed up at closing argument. I stood up to begin my argument as a plaintiff, and before I could get started, the judge says, you know, Mr. Young, I see this case as you prevailing, but, you know, the most that I see you getting in damages is $60,000. That's it. I said, Your Honor, I felt the same way until I started examining the documents, and there is one, the most important document in the whole case, and I didn't recognize it until after evidence closed. And it's in evidence. I'd like to give you a copy of exhibit number blank. I handed it up to him. I handed a copy to the defense counsel, which you always need to do. Anything you give to the judge, you need to either let the other side see first, or you need to provide a copy of it to them. And the judge says to me, what am I supposed to see from this? And I proceeded to walk him through the document, half a page email, and tell him why it was that this little email demonstrated that the damages were more than $60,000. The light goes on for the judge, just as it went on for me. And the defense counsel stood up to begin arguing to some of the toughest cross-examination I have seen in a long, long time. The judge ended up ruling in my favor with an award of the full measure of damages based on this one piece of paper. I didn't know the story until the end. Fortunately, I didn't try to shoehorn my client into what the story is. The client didn't recognize the power of the piece of paper because he's a layman. He just knows what happened to him. It involved the sale of trailers from a franchisee of an Indiana trailer manufacturing and selling company. But we ended up getting an award of the full measure because of this one piece of paper that I had no appreciation for. That's the problem with attorneys who are so intent on controlling everything and making sure that all of their witnesses tell a story that agrees with the story that the attorney wants to tell, regardless of what the truth may be, and browbeating the clients and witnesses into agreeing with them. That's the problem. We didn't live the story. We don't know it. And if we're playing that kind of a game, we put on blinders and we miss the whole story, the whole feature that we're trying to deal with. Now, I I've got a lot more that I could tell you today. Unless somebody has some more questions, I've got 10 minutes left, and there are a couple of other things that I'd like to talk to you about. I do a webinar every 2 weeks. I've done 4 of them so far. We're planning on doing a total of 6. The webinars are in much the same way or format as what you've heard today. I talk about how to do things in the context of the lessons that I have learned and demonstrate and show you through stories from the trials that I have been engaged in how to accomplish what you want in jury selection. I call my webinar series Taking the Dire Out of the Voir Dire. Like I say, we've done 4 of 6. Our next one is going to be December 6th. It's a Saturday morning. I start at 8:30 a.m. Pacific time. That may be a little early for the people on the West Coast, but it doesn't ruin everybody's day who are out in the Mountain or Central or Eastern time zones. So you can come and participate in the webinar. It usually goes for about an hour and a half, even though I promote it as an hour, because I always want to give you your money's worth. If you're interested in this, you can register for it at masteringthecourtroom.com/5. And I've got that up on the screen right now so you can see it. It's going to be December 6th, 8:30 a.m. to 9:30 a.m., but more likely 9:45 to 10 o'clock Pacific Standard Time. Now, if you've stuck it out this long, as I told you, I am going to share with you a coupon code that you can use to get discounts on our jury selection webinar, and I'm also going to make the coupon code work for the archived versions of the 4 previous webinar sessions that we have. If you register for the jury selection webinar number 5 at masteringthecourtroom.com/5, use the coupon code SAVE30, because what that will do is get you a 30% discount. But I'm going to go that one better, because I told you I'd make 2 offers to you. If you register and use the SAVE30 coupon code, I'll give you a coupon that your friend can use to attend the same webinar for free. So in effect, it's 2 for the price of 70%. I don't care how you split it up. You can pay for the whole 70% and give it to a friend as a gift, whatever you like. You can split the cost of the 70% between the 2 of you. But I'm making this offer because you've stuck it out on a Wednesday night. Thanksgiving's coming. There are lots of other things you could have been doing, and I am so appreciative for all of the people who have attended this session. But here's the second offer. You can use the same code to get a 30% discount on any recordings of the previous webinar sessions that we have up online, and these are all at masteringthecourtroom.com. This will be good until Friday, the 28th at midnight. If you want to get any of these, use the coupon code, buy the archived webinar sessions, you save 30% on it, but it's only until Friday. So I'm urging you, sign up for 5, save 30%, plus get 1 free. Sign up for any of the webinar sessions that you've missed. I can tell you that, number 1, I go through my new technique for picking juries. Number 2, I talk about that same technique, and I talk about how to construct stories in the form of the way that people write novels. In fact, I actually break down the Da Vinci Code to show you how Michael Brown structured his story, and there is a definitive structure in movies and novels that are published that we as attorneys never learn. Well, I'm telling you what that structure is so that you can start creating and crafting stories along the lines that the professional storytellers do, that they use to create tension and build powerful endings. That's number 2. Number 3, I talk about the matador in decision making and how people make decisions before jury selection is finished. And that's why jury selection is so powerful. The people that tell you that the jurors make their decision based on the opening statements are wrong. People make decisions on who they trust and whose story they're going to accept based on jury selection, so that the decision that they're making on opening statement isn't a decision. They're simply hearing the story in the version that they have already accepted because they've decided who they trust. I give 18 questions that you should never ask in jury selection. Or excuse me, 5, and I give you 18 questions that you should ask to learn who your extremists are. In session 4, I teach the power of silence in jury selection and how the worst possible juror is actually your best friend in the jury box, and how you deal with them as the matador staring down the charging bull to develop the best dialogue where the attorney disappears and the jurors are talking to each other. If you can get your jurors doing that, you now know that everything you're getting is true and not filtered by political correctness or embarrassment by the group. You are conducting real jury selection when they're talking to each other rather than you. These 4 webinars, I believe, are some of the best out there in teaching what you never learn in law school. And I have not seen very many places you can go to get this type of information. The coming 2 webinars are going to be building on this information so that we create a situation where I presented material that can make you an incredibly powerful attorney in front of the jury when you stand up not knowing anybody and it's time for you to speak to complete strangers and try to figure out whether they're the people that you can connect with so that you are willing to entrust your case, plaintiff or defendant, to this group of strangers. So I'm making that offer to you. 30% discount on any of these webinars that we've already done that are on tape, provided you buy them by Friday before midnight. And I'll give you a 30% discount on our next webinar plus a free one if you use our coupon code. I give a money-back guarantee. It is no risk for you. If you buy one of our webinars on tape and you don't think it's worthwhile, I'll refund your money. If you attend the 5th webinar and don't like it, you don't think it's worthwhile, just tell me. You don't have to give me a reason. Just say I want my money back. I'll give it back to you. Because just like I want credibility with my juries, I want credibility with you. You are people out there who've taken the time to sit through this today with me. I will back up everything I do with you with a money-back guarantee on anything that you spend a dime on with me. If you don't like it, you don't want it, whatever the reason may be, you don't even have to tell me the reason. I'll give you your money back. Finally, thank you. This is an exercise for me that makes me a better lawyer. And you attending this webinar with your questions and the things that we have discussed contributes to that. Without you, I wouldn't be doing this, and I really, really appreciate you taking your time on a holiday eve to be with me for an hour. All I can say is thank you. I'll give you my telephone number if you want to send or call me about questions, and I don't know anybody else that will do that on a webinar nationwide, but my cell phone number is 949-338-4459. Here are my email addresses, social media, my blog, which is Young on Trials, and Mastering the Courtroom is my site for the webinars. Ask me anything, ask me anytime. I'm willing to help. This is how we make each other better and help each other with the struggles that we have. I see this as somewhat altruistic on my part, sharing my experience, but it's more than that. I enjoy sharing what I know with people who are interested in doing trials because there are so few people who really, truly want to do trials. Now, if you felt like this has been worth it, go over to that chat box on the corner and just send me a yes or whatever, because I'm getting ready to turn this thing off right now, but I have really, really enjoyed being with you tonight. And we're going to do this again. Like I say, we may set this up to do it once a month. go to Young on Trials and register there. I think we have some people who haven't registered with us who are attending tonight. But get on our email list, because we'll send out the email when we're going to do this the next time. You can start putting your questions together. If you're involved in a case or doing something, write it down and send me an email. And we'll make it the subject of one of these webinars of question and answer. But it's a way that we do this. I'm getting a thanks, Steve. Appreciate your help. Yes, absolutely worth it. Thanks, Steve. You don't know how good this makes me feel, and all I can say to all of you, thank you very much, and I look forward to the next time. This is Steve Young, YoungOnTrials.com, MasteringTheCourtroom.com. Thank you so much, and go to trial. Goodbye, everybody.